Hello, I'm Professor George Contreras. I teach in the areas of property and intellectual property law, and I'd like to speak with you briefly today about COVID-19 and the way that it's impacted patent law in the United States. So, it's fairly well known that COVID-19 has led to shortages in medical supplies, protective equipment, ventilators, as well as a dire need for the development of new vaccines, diagnostic kits, therapies, and other innovations. There's a significant need for innovations like this to respond to contain, and eventually to cure the disease. So in the midst of this, back in March and even earlier, news reports began to emerge that intellectual property rights, patents in particular, were beginning to be asserted to hinder efforts to combat the disease, and to have supplies manufactured and distributed where they were needed. It's no secret that a large number of patents cover potential vaccines, therapies, and equipment used in the fight against the pandemic. There was one highly publicized incident in March regarding two volunteer engineers in Italy who were 3D printing ventilator valves and providing them to hospitals that needed to repair ventilators. These engineers, it was reported, were then threatened by the manufacturer of the ventilators for potentially violating a number of intellectual property rights in both the digital design file and even potentially patents covering those designs. There are other instances also that were publicized regarding the assertion of patents by a patent assertion entity that held patents from the now defunct Theranos company relating to blood testing, as well as a number of other manufacturers and pharmaceutical companies with patents relevant to the fight against COVID-19. So there have been a range of responses relating to this phenomenon. And we've seen them in a couple of areas. First are potential compulsory licensing solutions proposed by governments. Compulsory licensing means that the government can require the holders of patents or other intellectual property to permit others to operate under that intellectual property, often for some reasonable fee that's determined either by negotiation of the parties or sometimes by a government agency. And we've seen these types of orders in the COVID-19 pandemic already issued by countries including Canada, Israel, Chile, Ecuador, France, and Germany. So some large countries that typically don't issue compulsory licenses in health crises. In the United States, we have not had any kind of compulsory licensing issued. But there are two possible routes in the United States that could be used and that some have suggested be used in the fight against COVID-19. One of those is federal Marchin rights under the Bayh-Dole Act of 1980. Under that act, the federal government has the right to come in and require the licensing of any patent whose inventions were funded by the federal government. So a lot of research that goes on in academic research settings and even in the private sector to some degree, if it's funded by the federal government, the government can require that licenses be granted to others if necessary to supply products or services to the economy. The second possible mechanism in the United States that could be used in a compulsory manner is what's called government use under Section 1498. Government use doctrine says that the federal government can operate under or have its contractors operate under any patent without permission of the patent holder on the condition that they submit to a royalty determined in the Court of Claims. Right? The patent holder's only remedy for that government use is in the Court of Claims, which will then create or determine a reasonable royalty for that use. Government use under Section 1498 has happened before. It happens frequently in the case of military products and supplies. It's also happened more than 50 times in the case of drugs of one kind or another over the past decades. It has not yet been used with respect to COVID-19. There are a couple of reasons for this. First, there is not yet a vaccine. Perhaps when that is developed, we will see more tendency to use it. There are test kits, however. The government hasn't exercised its government use rights yet, and there are potentially several reasons for this. One is the divide between state, local, and federal governmental roles in the testing for COVID-19. Government use under patents only applies in the case of federal governmental use. Okay, those are compulsory mechanisms to get around patents and other intellectual property that might relate to COVID-19. In addition to these, there are some voluntary mechanisms that have been discussed in connection with the current crisis. One of these is a fairly prominent patent pool proposal made by the government of Costa Rica to the World Health Organization. The World Health Organization's UNITAID arm already has what's called the Medicines Patent Pool, a voluntary structure whereby drug companies can license their patents generally relating to HIV, tuberculosis, other infectious diseases to this pool, which will then sublicense those rights to generally generic drug manufacturers in the developing world, usually for a modest royalty or potentially no royalty at all. That pool, the Medicines Patent Pool, has been around for the last 10 years, and it does achieve the goals that it set out to. But bear in mind, it only is focused on the developing world at this time. There have been some proposals and calls for the Medicines Patent Pool and WHO to expand its scope to encompass COVID-19 and related cures, therapies, and also to expand its scope beyond the developing world to the entire world, which is the subject, of course, of the pandemic. Those discussions are currently underway. In the meantime, there have been a number of private efforts to do similar things, both in the academic sector and in the private sector. So universities like Stanford, MIT, and Harvard have produced what we call a pledge to commit their patents to the fight against COVID-19, to do so rapidly and in a way that will make those patents available as cheaply as possible to those who need to use them. The ventilator manufacturers Medtronic and Smiths have made ventilator designs available and say that they won't charge for patents on those ventilators, enabling others to manufacture both the ventilators and parts for them. AbbVie, the pharmaceutical company, has committed that it will not assert patents relating to its HIV drug, Kaletra, which at least a few months ago had some prospects as being available as a therapy for COVID-19 as well. And then the final effort that I'll mention is something called the Open COVID Pledge. It is an open-ended public pledge that I and a number of other academic legal experts and scientists, both in the United States and in Europe, have gotten together to create. Basically, it's a simple statement that can be found at opencovidpledge.org, in which a company or an institution can commit that it will make its patents or copyrights available for the fight against COVID-19 to anybody who wants to use them at no charge during the duration of the pandemic and for 1 year afterwards. It is a limited scope, limited time, free license that is intended to open up the field so that as rapid and effective a response can be mounted against this current emergency. So far, there's been significant take-up. Close to 300,000 patents have been pledged by companies ranging from Intel, Microsoft, Facebook, Amazon, Hewlett-Packard, Enterprise, IBM, Fujitsu, and more large companies to very small companies, to an academic institution, to a couple of national laboratories such as Sandia and the NASA JPL laboratory, all of which have pledged that they will commit their intellectual property and patents for this limited purpose without giving them up more generally, so that after the pandemic or for indications beyond COVID-19, commercial licenses can still be granted, the patents still have value, but for purposes of responding to this particular emergency, those typical instincts to charge for patents and control their use have been relaxed. So hopefully that is a helpful overview of some of the very interesting and novel issues relating to patents that have come up in the COVID-19 pandemic.